They say, what the heck is that? You're gonna fabricate this unconstitutional nonsense? You even admit it that it's not constitutional. There's no law there that allows you. And it might be interference with something like the peaceful transfer of power. Yes! Eureka! Apparently feeling unburdened by what has been, oh, Todd! In New York's Court of Appeals, Alvin Bragg asks Your Honor to make new law contrary to binding precedent. Trump's nominee to work at the Department of Justice, Todd Blanche, is obliterating Alvin Bragg, one of the remaining prosecutors who was still trying to go after President Trump, wanting to sentence him, even though he's been reelected to the White House. And we've gone through Alvin Bragg's big 82-ish page response to President Trump after the election. Remember that Judge Merchan, in the 34 false business records case, has postponed the sentencing. There were guilty verdicts, but the sentencing has not occurred. Trump said, too late, case is over. Trump is transitioning into the White House, so you have to stop. Alvin Bragg said, no, 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 no. We have to keep this thing on track. We're going to have sentencing, or we can just hold this case off until Trump leaves the White House, and then we'll just pick it right back up. Here's how they start. All right, Judge Merchan and Alvin Bragg. President Donald Trump respectfully submits this reply, and this is the final word. So it was Trump's original motion. He moves first. Alvin Bragg moves second. Trump hits the final reply. In further support of our motion to dismiss the indictment and to vacate those jury verdicts that were verdicts of guilty. And we're responding to Bragg's filing that we read earlier this week. Now, on December 11th, Democrat Senator John Fetterman, you know him, reposted an article about Alvin Bragg's opposition on Truth Social with the following comment. Fetterman's on Truth? It was his first one. John Fetterman went over to Truth Social and he said, here's my first truth on here. He said, the Trump hush money and Hunter Biden cases were both BS, and pardons are appropriate. Weaponizing the judiciary for blatant partisan gain diminishes the collective faith in our institutions and sows further division. Pretty articulate there, John. Now, as to President Trump, Fetterman's summary of Alvin Bragg's behavior is apt. So Trump's people, we don't have anything to do with Hunter's case. I don't care what his position is on Hunter. We have no skin in that game. So, all right, call David Weiss, Biden's own DOJ, I guess. I guess you can call Biden's own prosecutors BS. All right, whatever. But what he's saying, a senator is saying, Alvin Bragg is weaponizing the justice system in the Trump prosecution for hush money. Whatever, it was the false business records, right? It was paying off Stormy Daniels. It was a spreadsheet crime because he didn't write appropriate classification in or something. No one knows. Even the jurors don't know because they could pick whatever they want. So Alvin Bragg's brief includes a request that the court disregard the New York Court of Appeals and fabricate this unconstitutional abatement law, remember? And we were making the distinction. Trump is saying this case must be dismissed. Dismissed versus terminated. Trump wants it dismissed. Alvin Bragg wants it terminated. He actually wants him sentenced. But if he can't get that, his backup plan B was, how about we just use this abatement thing? Like if you die, we can do it. If you die, Trump's not dead, but our ambitions are dead. And so it feels like our souls are dead. So maybe we can pretend he's dead since you think he's probably dead, Merchan, you know? So just make it terminated. They say, what the heck is that? You're going to fabricate this unconstitutional nonsense? You even admit it that it's not constitutional. There's no law there that allows you. He admitted it when we read it earlier in the prior motion. This is all based on an extremely troubling and an irresponsible analogy between President Trump, they're going there, let's do it, who has survived multiple assassination attempts, and you're trying to make an analogy that this is like a case where somebody just drops dead? Irresponsible Alvin. You should know better than this. And he will soon be the only person who alone composes a branch of government. And a hypothetical dead defendant is who you're comparing him to? Now that unhinged contention, Alvin, demonstrates conclusively that Alvin Bragg is a sick person, and the District Attorney's Office of New York cannot be entrusted to separate their political motivations and their career ambitions from their obligations to seek justice. Now, Bragg has no credibility left in these proceedings at all, and they must be terminated immediately to prevent additional constitutional and legal violations. Trump's defense continues. Deputy AG Alvin Bragg, Associate AG Emil Bove coming in, saying immediate dismissal is necessary, and it needs to happen now. As president-elect and the soon-to-be president, Judge, there can be no further criminal proceedings against President Trump at all. Such proceedings interfere with the ongoing transition process, including preparations that are necessary for President Trump to effectively carry out constitutionally designated functions. Therefore, under the Presidential Transition Act, immediate dismissal and a vacature of the jury verdicts are necessary. So just strip those up like Nancy Pelosi in Congress with those official records. Alvin Bragg did not address a single word of the Act's text when he went through his little whiny response previously. Since 1963, Congress has prohibited, quote, any disruption to the transition process in order to avoid the harm of the safety and well-being of the United States during a period when the president-elect is arguably making more fateful decisions than he will have to make after he's sworn into office. He's building his whole team right now. They put that into the congressional record when they were having these conversations back in 1963. Now, the Transition Act reinforces the doctrine of sitting president immunity because, as the law clearly says, the president-elect's transition activities are integral and they're preparatory to his imminent actions as president. He's in training season. It's like that whole sequence in Rocky, man. There's a lot happening. Everybody's flying all over the place. Trump's running up and down stairs. DA Bragg's obstruction of this congressionally mandated federal function, and see that word there? Alvin Bragg's obstruction. Oh, yeah, that's right. It is obstruction, isn't it? It certainly feels obstructive. And you know what else it feels like? It might also be interference. And it might be interference with something like the peaceful transfer of power. Yes! Eureka! Obstruction and interference happening right now with the peaceful transition of power by the Democrats. And that obstruction impedes upon the federal functions, and it imposes dangers of intrusions on the authority and the functions of the executive branch that Trump is preparing to assume on January 20th. President Trump's extensive transition activities, which are happening right now, for example, are choosing his cabinet, meeting with world leaders, preparing day one executive orders, and other policies. These are all integral to the official conduct as president. Now, Congress and the Office of Legal Counsel and all other reasonable sources recognize that these are all consuming tasks that are necessary during the short transition period, and that these undertakings are critical to the national interest and our national security. And Bragg's conclusory assertions to the contrary transgress Article 2 of the Act and the Supremacy Clause, and they are inciting, we'll come to it. Now, Alvin Bragg's feigned ignorance of the Supremacy Clause demonstrates the importance of the constitutional restriction on biased, incompetent prosecutors. Now, Alvin Bragg purports to be confused, I don't know how this works, about the operation of the Supremacy Clause in this setting. He says, well, it seems that President Trump's position appears to be based on intergovernmental immunity. Are you confused, Alvin? Alvin Bragg's mischaracterization does not reflect the law. Let me educate you. The Supremacy Clause is a key part of the basis for applying presidential immunity to prevent these improper local proceedings from interfering with the sanctity of the electoral process and the functioning of Trump's executive branch. Federalism and comity support the same result. We're in the same country, okay? We're federal government and the state government. We have this dual system, but we're also friends. Now, since at least 1879, courts have repeatedly refused to let biased state prosecutors like Alvin Bragg and Fannie Willis and Tish interfere with federal officials and their official functions. In Vance, a Supreme Court case that worked its way up through the Second Circuit and the DOJ emphasized these concerns as particularly forceful when we're talking about the presidency. And even Alvin Bragg recognized that the operation of the Supremacy Clause, he wrote, was, quote, very analogous to the separation of powers problems that arise in federal immunity cases. So we do have to protect the presidency against certain impediments, right? He was recognizing that because in his filing that we talked about previously, he agrees while you are the sitting president, you can't prosecute him, right? Because of the impediments and the shackles that it puts on the executive. Now, Trump cited the same authorities back in July, Your Honor, when he submitted a motion to dismiss to you. Now, in response to that motion, when Alvin was responding back then, he didn't suggest any confusion. So now all of a sudden he's confused. He doesn't know how this works. Now, he disregarded nearly all the same cases that he already referenced, wrongly mischaracterized the arguments as relating to, quote, quote, intergovernmental immunity, and relied principally on tax burden case law that is not even cited in Trump's motion to address their straw man. This is good stuff, man. So you created a bunch of things that we never talked about, right? In other words, you said Trump is pulling on intergovernmental immunity. It appears Trump's talking about intergovernmental immunity. No, maybe that this is a tax burden case law. We're going to cite these cases. We're not talking about taxes either. We referenced the Presidential Transition Act, which you didn't reference. You didn't even talk about. We talked about the Supremacy Clause, which you ignore, and these other cases that are just not part of your analysis. So the court, do not be misled by this weak parlor trick from these goons. Even on Bragg's own terms, it would, quote, directly obstruct the activities of the federal government. He wrote in his filings for this court or for his own office to impose restrictions on President Trump. He admitted it. Then now he's confused. Now the prohibited obstruction, there it is again, resulting from these local proceedings in violation of this Supremacy Clause includes any type of sentence as well as a continuation of the gag order, because Trump is having his rights now limited. He can't speak about this judge and this judge's daughter and their Democratic alliances and how the judge made donations to Joe Biden and to stop Trump organizations. And that violates President Trump's extraordinary power under the Constitution to speak to us. Now, presidential immunity, as we know, categorically forecloses further proceedings here, Judge. Alvin Bragg conflated distinct strands of presidential immunity upon you in an error that pervades their entire brief. Alvin conflated two distinct forms of presidential immunity because he can't keep them straight. Current and former presidents are immune from prosecutions that are based on or involve evidence relating to their official acts. Now, Alvin violated this form of immunity in grand jury proceedings and again at trial. And in addition to that, and distinct from this is official act immunity, sitting presidents are absolutely immune from all phases of criminal proceedings, regardless of whether the proceedings are based on official acts or unofficial acts. All phases. As a president, it stops. Thus, for purposes of this motion, Alvin Bragg's false claim that their case is, quote, wholly based on unofficial, not official acts is irrelevant. The burdens imposed on a sitting president by the initiation of criminal proceedings, whether for official or unofficial wrongdoing, are unacceptable. They violate the Constitution. So once he won, this whole distinction went bye-bye. Doesn't matter, okay? He's the president now. He can't be prosecuted, and he's transitioning into that role. So you're done. Enforcing sitting president immunity by vacating the jury's guilty verdicts and dismissing this case doesn't render Trump above the law in any way. In fact, this motion affords all due respect to that well-worn phrase, which is rhetorically chilling but wholly unjustified. It's a stupid phrase. No one's above the law. Clearly, the Democrats have a bunch of people that are above the law, including the judge that Joe Biden that was selling kids to prisons. The federal Constitution, which guarantees presidential immunity, is the supreme law. So abiding to that is above Alvin Bragg. So we're actually following the main law, not Alvin Bragg's hack construction of New York law. Now, under that Constitution, which is the supreme law of the land, Alvin Bragg cannot impede President Trump's sweeping powers and duties. Accounting for that reality and ensuring that the president may exercise those powers as the framers anticipated doesn't place him above the law at all. It preserves the basic structure of the Constitution from which the law derives. Alvin is the one acting out of constitutional order, not Trump. And even Jack Smith agrees with this. Alvy, the DOJ dismissed it. Alvin, Jack Smith, even he is not a real prosecutor. Even he dismissed it. It reflects a proper application of a categorical bar on criminal proceedings against Trump. Nothing in their submission from the feds suggested that Bragg's claims about procedural and substantive differences, which is what Bragg cited. He's like, well, mine's different than his because like we're a state and he's feds. It's different. Well, nothing in Jack's dismissal said, well, we could continue this if we only had these differences. No. Bragg now seeks to distance themselves from Jack. Jack's running away. Everybody wants to distance themselves from Jack. He's probably screaming for pardons right now, along with the rest of those crooks. Everybody wants to distance themselves, and they're still trying to distinguish between official and unofficial acts. Okay, well, Bragg argues that Jack's prosecution was based on Trump's official acts. He says, well, mine wasn't. And claims, contrary to their grand jury and their trial record, that their case is not. Remember, the trial was riddled with official acts, evidence, and testimony. They had two official government witnesses who worked for Trump come in and testify. This contention overlooks the fact that Smith recently devoted 165 whiny pages to arguing that his DC prosecution was not based on official acts either, right? It was so not based on official acts that he spent 165 pages explaining why it wasn't based on official acts, you know? What do you need a full book for to explain it, Jack? I mean, if it's not based on official acts, what's all this explaining for? Oh, it's clearly on official acts. It's clearly based on it. Although Trump disputes Smith's arguments, the salient point is that the DOJ's dismissal was not based on concession of official act immunity. No, just the opposite. Saying the prohibition on this is categorical. It doesn't hinge on whether it's official or not official. It's categorical and doesn't turn on the gravity of the crimes charged or the strength of the government's proof or the merits of the prosecution. The people vetoed you. The Constitution requires this case be dismissed before Trump is inaugurated. That's what Jack Smith said, okay? The DOJ interprets it this way, so Judge, you better get on board with that interpretation because the federal government says that. Don't come back and say, well, this is different because it involves Stormy Daniels and Cohen and personal payments to a personal lawyer and all. Nope, doesn't matter. Trump's arguments relating to the supposedly temporary nature, Bragg's arguments relating to the temporary nature of Trump's immunity does not support a different disposition. Regardless of whether the immunity is temporary, the DOJ and the Office of Legal Counsel have rightly recognized that Trump's immunity currently applies to him now. It precludes ongoing criminal proceedings and it requires a dismissal. They said the proper balance supports recognition of temporary immunity while the president remains in office from the criminal process. Now, nothing in the analysis of this issue by the executive branch or the courts suggests, as Bragg does, that presidential immunity turns on whether pending proceeding is advanced or not. The required vacature and dismissal are not unduly prejudicial to any valid interest of Bragg, okay? They failed to timely achieve their political desired result. They initiated this lawfare campaign 6 years ago, and this was based on record entries that harmed nor deceived anyone. All standard stuff. And so Bragg, he has to be bound by their concessions in another case. Now, in addition to the force of DOJ's conclusions about Jack Smith's case, Bragg is bound by their previous concessions. In another case, Bragg conceded that there were two distinct forms of presidential immunity that are relevant to this case. Bragg said this: "We're mindful that as a state actor, as a prosecutor, our office cannot investigate a president for any official acts and that we cannot prosecute a president while in office." They wrote that a while ago. That's what the DOJ said. And they've been saying that since 1973. Thus, the posture of this case is not any different. They made that case up to the Supreme Court when they were filing their petitions there. He also acknowledged that courts are empowered to shut litigation down where cases have real burdens on the presidency. That's what's happening now. This year, the Supreme Court issued a binding decision concluding these burdens are unconstitutional. And so, sorry, Judge Merchan, Your Honor, you must now do what even Alvin Bragg conceded when he was filing his positions during the appeal. Alvin Bragg conceded that Trump has immunity. He said it. And his opinions were well-founded and inescapable back then. Sitting president immunity requires Trump not to be subjected to any criminal proceedings, right? And their arguments, like they were conceding part of it. They're like, well, when he becomes president, then we have to stop. But he's not president, so this is the line. We're like, well, now the line has been crossed and he won. So now what? Got to eat those words. So their prohibition is categorical. The Constitution does not permit a, quote, practical inquiry into what Bragg says will happen after the presidency or happen during the term. Bragg lacks any qualifications to even make a guess. The court cannot put the country at risk based on Alvin Bragg's jaded crystal ball as Bragg looks ahead to his next election. Now, the OLC has come with a categorical rule consistent with the Constitution that doing a criminal process and proceeding here is perilous. Now, when the Supreme Court has engaged in balancing to weigh presidential immunity versus public interest and more, it has done so based on the type of proceeding at issue, but not the case-specific posture. So it didn't really matter where we were at the case. It was the type of proceeding. Doesn't matter if we're early in the case or late in the case. Fitzgerald was at an advanced stage. There were 4,000 pages of testimony. In other words, it doesn't matter that we're just like 1 inch away from a sentencing. Okay, Bragg's like, we're so friggin' close, man. Just let us sentence him, please. It doesn't matter. Too late. Vance was based on 200 years of precedent about subpoenas and other things, and so it doesn't matter. Doesn't matter where we're at. It hasn't happened, and now you're done. Finally, as with other opinions and other courts' reasonings about Trump's immunity, this decision is based on institutional considerations, not timing considerations, and so it is a categorical bar. Now, Alvin Bragg went through, and in his filing, he said this is not going to be that big of a deal on Trump. So one of the reasons reasons we don't want this to happen is because we don't want prosecutors to burden the presidency, as we've been reading. Alvin said, well, it's not going to be that big of a burden. Let's just say we're not going to put him in jail, and that'll be good enough. Then he won't have to worry about it. And if he's not worrying about jail, then it's not really a burden, and so we can continue on and come back with sentencing after the presidency is over. But they say that's ridiculous. That's not a minimization of the burden. Trump's immunity and the corresponding prohibition on any criminal proceedings targeting a sitting president is based on three burdens: sentencing threats like going to jail, a stigma, and distraction from official duties. And could you imagine if we just had to deal with Mercan sitting there oh, I wonder what Trump is doing today. I can't wait to see him 4 years from now when he comes back to my courtroom. And Alvin Bragg and all of them well, we're going to pick this back up, hanging it over his head for 4 years, having to deal with this crap. No, Bragg gives impermissible short shrift to each. Okay, this is a big burden. First, Bragg carefully avoided acknowledging that Trump cannot be sentenced right now. He can't even admit it. It is clear that incarceration is out of the question. So don't even think about it, Judge. It's out of the question. Nor may Your Honor impose any restrictions or disqualifications that would apply during Trump's second term. Even potential criminal liability are unacceptable. Nor can New York impose any form of probation on Trump, which would also cause unconstitutional burdens arising from liberty restrictions, the threat of revocation and further probation violations, which are new criminal charges, and associated penalties with that. So you cannot even penalize him. And second, Alvin is wrong that the only relevant stigma that results from the, quote, initiation of criminal proceedings matters. There is a peculiar public opprobrium that attaches to criminal proceedings at every stage. Yes, at every stage. Bragg's post-trial emphasis is on irrelevant and disputed allegations, like in the Bergdorf case with E. Jean Carroll, who says she got Bergdorf in a dressing room at Bergdorf's. It helps to illustrate why that is so. It's also obvious, as the Office of Legal Counsel says, that stigma arises not only from an indictment, but also from the need to respond to those charges throughout the process. Now, Bragg will undoubtedly amplify the stigma arising from these proceedings. If Bragg is allowed to just pause the prosecution and bring it back, he's going to make it a point every day as he's running for re-election to say, as soon as Trump leaves, we're going to prosecute him again, and I need to be the guy to be here to do that. There's a serious stigma here. And if he can do that, that's going to seriously interfere with Trump's presidency. And third, Alvin says, well, we can just come back for sentencing as soon as the presidency's over because we need to continue fighting these. And he says there's no burdens that are going to need to fight these because it's basically over. They say, what? No. Every point of every criminal case requires every defendant's personal time and mental preoccupation. Yeah, Trump is choosing to continue to fight this. So saying, well, Trump can choose just not to fight it and worry about it and just bend over and take it. No, they say Trump is going to fight it. He does choose to fight this on every single front, Alvin, until your pathetic display is put to an end. It is Trump's constitutional right to do so at each step along the way by fully participating in his defense, as he has from the outset. Now, Alvin makes a peculiar constitutional argument by suggesting that the president's ability to do his job should not be disrupted because Trump could just waive his constitutional rights and just go and plead guilty. Now, the Constitution should not lightly be read to put a chief executive officer on such a notice and such choice. And that the advanced stage of this case heightens and does not diminish the risk of interfering with his role. Just because we're almost close to the end doesn't mean anything. In fact, you get more tense. You're going to be sentenced. It's like, you're going to go to jail? What? Bragg's claim that a defendant likely feels greater apprehension about the future actions of a prosecutor than during subsequent stages is indicative of their complete lack of awareness about the catastrophic and historic failure of their weaponization of the justice system. The irresponsible and at times unethical behavior by Alvin Bragg and his underlings has only increased over time. No participant in the defense against this unprecedented abuse of criminal justice system is less concerned today than we were a year ago. To the contrary, it is abundantly clear at this point that Alvin will say and do anything, including urging the court to disregard the Constitution, the New York Court of Appeals, and the Second Circuit to try to make this abomination stick. The threat of a potentially imminent sentencing in front of psycho Judge Mercan, my words, increases the need to devote attention and urgency to each motion that is necessary to further demonstrate how lawless these proceedings have been since the inception. That threat enhances the risk of distraction from the president's duties, which are of unrivaled gravity and breadth. Now, Bragg's arguments to the contrary diminish the crucial role that a defendant plays in the design and the presentation of his own defense, and and they disrespect the criminal justice system that Bragg has failed to protect. Trump's defense continues, writing, Alvin Bragg's politically motivated interests don't override presidential immunity, saying his interest, which is like, we have to just maintain the jury's verdict as a notch in whatever belt he plans to wear for his campaigning in 2025, is no basis to interfere with the executive branch. Bragg quotes a Bond versus U.S. case, saying that, quote, traditional state authority includes punishment for local activity. Well, suffice it to say that, dating back to 2018, this case has been anything but traditional, Alvin. Trump's motion does not require the court to assume that Congress has meant to effect a significant change here between federal and state jurisdiction. Nobody, neither Congress nor the Supreme Court, has ever tolerated disruption of the executive branch in favor of a local prosecution. Never happened. Here's cases that show that. Likewise, the Second Circuit also denied Alvin Bragg's request that federal courts abstain from the dispute in a subpoena in advance. And so thus, even if Alvin had proceeded in a matter with the public interest in fair and effective law enforcement, which he hasn't, that consideration would not justify casting aside immunity, which is designed to protect the presidency. The balance of competing interests requires recognizing presidential immunity, because otherwise being prosecuted impedes and burdens the presidency. Now, they continue telling us that Alvin's little accommodations, remember Alvin was like, well, how about we just agree we're not going to put him in jail, and then Trump won't have to worry about going to jail, and then that's good enough. And then if you don't like that, how about we just pretend like Trump is dead, and then we can just terminate the case because there's no law that allows us to do that in New York unless he's dead. So just pretend he's dead. So they say, look, these accommodations are unconstitutional and totally lawless. Bragg's so-called accommodations, anything short of a dismissal of this case, are a strained effort to position their zombie case like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. Alvin Bragg and Tish James popping up. This zombie case must be put to rest. The zombie case, which started in 2018 and it involves decades-old false allegations, cannot simply be stayed until Trump leaves office in 2029. Bragg's proposal would violate not only presidential immunity, but also due process, the Sixth Amendment and the Eighth Amendment. Bragg asked the court to hold the case in abeyance and claims that the appellate courts could do the same, but the Office of Legal Counsel recently rejected that course of action based on 50 years of unquestioned analysis. They concluded that a grand jury shall not be permitted to indict a sitting president, even if all subsequent proceedings were postponed. Still can't indict him, sorry. Trump would be legally stigmatized. That's in violation of the Constitution, and the proposed stay would not do anything to help that. And their conclusions are grounded in reality. They're pretty compelling. Bragg offers no persuasive reason to avoid them. Staying the proceedings against Trump during the second term would impede the presidency. It would give New York County intolerable leverage over the executive branch, which exists for the protection of the entire nation, not to be worried about what Judge Merchan might think about Trump's foreign policy. Alvin and the court have asserted wrongly and without any evidentiary foundation that their gag order is still necessary too, insurrecting Trump's free speech as the president-elect of the country, not a private citizen anymore. Continuation of that unconstitutional prior restraint during the course of this hypothetical stay would result in this court and Bragg policing Trump's constitutionally protected speech, authorized by the Constitution, on threat of mid-presidency imprisonment and other unconstitutional penalties as well. Now, in addition, if we just pause this, it would require President Trump to lead the country while facing the ongoing threat that this court and this Democrat donating judge are prepared to impose imprisonment, fines, and other punishment the moment he leaves office. Now, to be clear, President Trump will never deviate from the public interest in response to these thuggish tactics. However, the threat itself is unconstitutional. In other words, Trump doesn't buckle or bend to any threats, doesn't even think about it. But the fact that there is a threat alone, even though it doesn't impact him at all in any way, shape, or form at all, period, it's unconstitutional by virtue of its existence under the Presidential Transition Act, under the Presidential Immunity Doctrine, and the Supremacy Clause, because it would exacerbate the stigma and the distractions and the burdens above. And so, for all these reasons, Bragg's accommodations of staying the case until Trump leaves has no legal basis and is completely unacceptable. Now, let's talk about their little fantasy land idea of Trump being basically dead. Now, here's Bragg's dark dream scenario. Why don't we just pretend Trump is a dead man and use abatement by death? It's not an option, Alvin. Nice try. As a further illustration of Alvin's desperate desperation to avoid legally mandated dismissal as required under the law, Bragg proposes that you, Judge Merchan, pretend, just make believe, as if one of the assassination attempts against President Trump had in fact been successful. Bragg also thinks, he says, quote, "It makes sense for Your Honor to pretend that the court is in Alabama, too." These abatement arguments are absurd. This court is bound by the existing case law surrounding abatement. In New York and at least 13 other states and federal courts, abatement is effectuated through the remedy that President Trump seeks. The indictment must be dismissed. That's how it works. This isn't Alabama. Apparently, feeling unburdened by what has been, oh, Todd, in New York's Court of Appeals, Alvin Bragg asks Your Honor to make new law contrary to binding precedent. Oh my gosh. Judge Merchan just flipped over his whole friggin' table. Setting aside stare decisis, which would be precedent, there is no good reason to do that. Now, states that have departed from this practice have expressed concern about the impacts of abatement ab initio on victims' rights. What happens if you just terminate it? What happens to victims? Here, however, it is not seriously disputed that there are no victims to even be concerned about. We're still in Alvin Bragg's abatement wonderland, fairyland. The proceedings would not be subject to appellate review because whatever's happening can happen. Who cares? It's Alvin's land. Welcome. Next stop, Tishville. Incredible. And so, wrongly suggesting that appellate proceedings could merely be held in abeyance. Oh, they're making it like hurt so bad. Merely. What do you mean merely? What does that mean? Is there like a standard in there just because you think it's merely holding a whole case in abeyance? Like not a big deal for you? Thus, Bragg has casually suggested that the court enter an order that violates President Trump's, quote, fundamental right to appeal. Well, forget it. Who cares? One would expect more from a first-year law student, Matthew Colangelo, and this is yet another indication that Bragg's opposition to this motion has not been undertaken in good faith. Now, the court cannot resolve this motion by violating President Trump's sentencing rights, so don't even think about it. Now, Alvin also asks Your Honor to impose, quote, certain limitations on a hypothetical sentencing that they're making up, that the court lacks authority to conduct. This judge has to be so mad, I can't even imagine how mad he is. The proposal lacks any legal foundation at all. There is no basis for any court, including this one, Democrat dono judge, to disregard the significance of President Trump's extraordinary leadership as a public servant. The fact that there can be no sentencing is a fact in order here, where President Trump's service to the American people would be a significant mitigating consideration. Now, furthermore, and particularly in light of the existing evidence of bias, conflicts, and the appearances of impropriety, it does not blunt President Trump's concerns for Bragg to suggest that the court simply disregard Trump's second term in office so that a 2029 sentencing can happen. The prospect for even an implicit bias to President Trump at a future sentencing threatens to impact his decision-making. Now, as noted above, even though Trump would never succumb to such a pressure, the threat alone is an unconstitutional intrusion on the executive branch. Now, that prospect is not, as Bragg suggests, some sort of trivial inconvenience. That is a grave and impermissible danger to the effective functioning of a second Trump administration that will be protecting the public across the nation from January 25 to 29. And finally, Bragg's suggestion that presidential immunity, while not requiring dismissal, should nonetheless require some other non-incarceratory sentence, only sheds more light on their completely unprincipled position. Bragg is correct that there is not a single thing about the zombie case that has ever warranted even the prospect of incarceration, of President Trump at least. But presidential immunity is not, as Bragg claims, a constitutional limitation on the range of available sentences. The doctrine is a complete defense to even the possibility or the danger of its outcome. Absolutely no condition, none, may be imposed on President Trump's liberty, as such restriction would be to the detriment of the country. The Constitution does not tolerate any impediment like that impedes the function of the government. And so the rest of the factors support dismissal as well. The foregoing immunity considerations that we just discussed, that alone is sufficient. It requires that our motion be granted and the case be dismissed. Now, Alvin does not dispute that there was no financial injury. There wasn't. And their aggrandizement of the zombie case with rhetoric about the sanctity of the electoral process, unquote, the integrity of the marketplace, it all rings hollow. They cite no evidence to support those claims, which amount to a concession of preemption error because Bragg Bragg improperly applied state law with respect to election to the federal office. Bragg was prosecuting a federal crime that the federal government and federal prosecutors did not pursue. Now, while it may be true that other people face consequences, those other proceedings are consistent with the conclusion that this one is not serious. Michael Cohen may have been in other problems. Doesn't matter to us. Bragg contends, he says that Pecker and AMI were found to have committed knowing and willful violations of federal law. Okay, but they weren't prosecuted. They made a deal. The same U.S. Attorney's Office that issued a non-prosecution agreement to AMI and required Michael Cohen, perjurer, to plead guilty, they declined to charge Trump. Bragg's inaccurate claim that the evidence was, quote, overwhelming proceeds by crediting the testimony of their serial perjurer star witness, Michael. In a weak and unsuccessful attack on President Trump's character, which is ridiculous, Bragg devotes 4 pages of their brief and a 115-page compilation of social media posts to confirming that they have no regard for the First Amendment at all. Bragg's discussion of politically motivated lawfare by Tish, who takes her shoes off, and E. Jean Carroll, who talks about her cats and blue painted trees and all sorts of other things, we can't say the words now, who got allegedly Bergdorfed, even though nobody has any real evidence of it, all of which is currently being challenged on appeal, provides no justification for this case. So the fact that other hack New York people are being hacks in New York doesn't matter here. There is no empirical evidence for Bragg's argument that this case has or will in the future will result in any meaningful general deterrence to crimes out there. If there has been any deterrence to speak of, it arises from the manner in which Bragg approached this case and how it has deterred public trust in a system that Bragg is supposed to administer. Dismissing the case will benefit the public welfare by removing unconstitutional impediments on President Trump, who has been duly elected. Bragg does not dispute there are no victims, and the real victims here are the taxpayers and the people supporting the salaries of Bragg and the 9 prosecutors who signed the opposition brief, all of them working on this, rather than focusing on escalating violent crime in the city like CEOs getting shot in the back. Therefore, none of Bragg's additional arguments outweighs the need for presidential immunity, which has been articulated. And Trump's arguments are not procedurally barred either. The 6th Amendment provides Trump with carte blanche to file whatever motion he feels necessary. So he can file this, and he's doing that. And by the way, Trump's commanding victory in 2024, all 7 swing states and the popular vote, constitutes good cause for arguments to the same extent as others. The court would be abusing its discretion by finding otherwise. Whoa. Don't try it, Judge. Now, Bragg's lack of respect for Congress and the Second Circuit is not persuasive. His insistence on rushing through unprecedented circumstances and front-running federal courts getting ahead of them, remember Jack was prosecuting his cases and he brought his forward earlier, has consistently led to significant problems, and that flawed strategy threatens the same result here. The Supreme Court has already criticized the, quote, highly expedited proceedings, racing to get him, that has led to erroneous and unconstitutional applications of the presidential immunity doctrine. Your Honor, you, Judge, must heed that warning. This is your final warning, because the court's next steps could result in the enfeebling of the presidency and our government. And as with the Supremacy Clause, Alvin Bragg professes confusion about why an intervening from you, Judge, would render the Second Circuit appeal ineffectual. One of the reasons we wanted to remove this is to vindicate Trump's rights and presidential immunity. That's why we took it up. The Second Circuit appeal is pending, okay? It's not hypothetical. You cannot ignore that. We are moving forward on that one as well. If this court issues a presidential immunity decision before the appeal is resolved, Trump will be denied his rights, and therefore the Second Circuit appeal is resolved. Now, this approach does not involve improper federal interference with state proceedings either. So Alvin Bragg saying that this would impede on their rights to redress their criminality. They say Bragg has failed to address any of the Second Circuit stuff. And so accordingly, if this court makes a mistake, if you choose error by not granting this motion, we're going to ask for a stay of your decision for 2 weeks because Trump is going to pursue federal injunctive relief. This is not a speculative request, okay? If you issue an order in opposition to what we've written, we ask for a stay because we're going up to the feds. It is an effort to preserve every procedural mechanism available for Trump so he can continue his transition preparations without lawless Alvin Bragg burdening the peaceful transition of power, insurrecting Trump's transition from a prosecutor's office. Now, for the foregoing reasons, Trump now says that this court should immediately dismiss this indictment and vacate the jury's verdicts signed by your friend friends, Todd Blanche and Emil Bove, coming in hot to the DOJ. Of course, we're going to be here waiting for the judge to issue a ruling. Thank you for subscribing and joining as we do, my friends. When that one drops out, we'll be here to unpack it